You got to grab her. You got to pull her around. You got to show that you're a man. Somebody did. While the other, so that means you were the one holding the gun with the drum, because the one that had the pistol is the one that was pulling her around. Hoodies, mask, gloves, a pistol, another gun that has some kind of, I don't even know what it's called. Each of those cases previously in court entered pleas of guilty, and each of them to the first degree felony offenses of aggravated robbery. The agreements were for a cap of 17 years in the institutional division on each of those. I've received the pre-sentence report. Have you both had an opportunity to review the report?
We have, Your Honor.
I have, Judge.
Any additions or corrections?
As I'm aware, Judge.
Yes, Judge, the state would like to call Detective Josh Jackson, please.
Detective Jackson? You'll just kind of slide over a little bit, sir. Right there's fine. Good morning, sir. Sorry you had to wait a little bit, but please raise your right hand. Do you swear or affirm the testimony you're going to give in this hearing will be the truth, the whole truth, and nothing but the truth?
I do.
Thank you, sir. Ms. Malfino?
Thank you, Judge. As the court has already done, would you please take judicial notice of the PSI? I say that specifically towards Detective Jackson's detailed statement therein. And I would just add a little bit of subsequent testimony to that.
Sure.
Would you please state your name for the record?
Joshua Jackson,
And how are you employed?
a detective with Beaumont Police Department.
And as a detective with BPD, is it your duty to investigate violent crimes such as homicide, aggravated robbery, et cetera?
It is.
And did you have a chance to investigate an aggravated robbery that occurred in October of 2025 at the Dollar General on Highland?
Yes.
And did you later learn that that aggravated robbery went hand in hand, for lack of a better term, with an aggravated robbery that had occurred at Dollar General in September, the Express Mart in October?
That's correct.
So within a 1 month time period, there had been two aggravated robberies of stores located here in Belmont, relatively close together.
That's correct.
All this occurred in Jefferson County.
Yes.
And can you describe for the court, you have elaborated in the pre-sentence investigation report, your thoughts a little bit, and obviously the court is aware of the nature of the offense, et cetera. A little bit more about your thoughts or the sentencing hearing before we get to the video.
So, both of these cases involve two guys that go into a store, one during daylight hours, another one during nighttime hours. Both victimizing a clerk that's there just trying to do her job. There's no glass barrier on either of these stores. These two guys walk in there, hold the clerk up in each of these instances, and proceed to rob the clerk for, at least in mine, money and some cigarettes. And for this to happen in daylight hours or nighttime hours to somebody that's just trying to go to work, isn't right. I mean, you don't go to work expecting to get robbed when you potentially have family at home, and during either of these robberies, something tragic could happen.
And Detective Jackson, I think it goes without saying, from both the perspective of the state and the court, but from your perspective as a detective, is violent crime involving firearms and youthful offenders here in Belmont something that has just become extremely prevalent, unfortunately.
Absolutely.
And is it something that you continue to investigate on a daily basis?
That's correct.
Do you think it would be helpful for the court to view, if you would, Judge, outside of the cameras due to the sensitive nature of the complainant in the case and her identity, the video from the incident in September at the Dollar General?
Yeah, there's two videos with just the Dollar General on this one that I brought with different angles. It's just giving an idea of kind of what happened to at least the Dollar General one. There's a lot that it's not going to show, which is the aftermath of it and speaking to the clerk and the terror and how she felt. Of course, that's all in the whole case, but at least these two videos will give you a sense of kind of what happened during that day.
Okay. So you want me to just put them here? I mean, I can turn this off, or I can just put them
Just
possibly on my computer and just watch it here myself.
That'd be fine. I did not mark them, Judge, because I believe Detective Jackson
That's the only thing that's on there.
would need them back for future investigation if the court would allow, but if not, I can make a copy for the court.
I have no objection, Judge.
Okay.
To you just watching it. I've talked to Ms. Malvino about it.
May I continue?
Yes, ma'am.
And Detective Jackson, obviously, the court has taken note of your statement in the PSI, but is there anything additional that you would like to add for the record with respect to the sentencing that you would like to see the court impose?
No, I think what I wanted to convey is mainly in that email that I sent.
Thank you. I have no further questions.
Thank you. Any questions?
No questions.
Thank you very much for being here, Detective. I appreciate you. Any other witnesses?
No, Judge, just a couple comments if I may.
Sure, go ahead.
Obviously, it asked to take the court to take everything into account, the fact that there are two aggravating offenses. Obviously, you are aware of the prevalence of these type of offenses in Beaumont involving young offender with firearms, innocent victims in this type of a case. Officer Riley's comments, I think, are also important, Judge. He's a very detailed PSI writer, and his caution against leniency, the state would concur with. In addition to the jail incidents, which show the court, as you're aware, that Mr. Watts cannot behave while in custody, so therefore what leads us to believe that he would behave while on probation. Based on those, Judge, I would concur with the offer of Mr. Nichols at 17 and ask the court for 17 years in each case.
Thank you, Ms. Malfino. Mr. Parker, you may proceed.
Your Honor, in regard to the write-ups, I've talked to him about those. Those happened prior to the his PSI, and that was when he was in maximum security. And from what I understand, it's a lot harder to not get in trouble there because of who you're around. But nevertheless, he has no juvenile record that I'm aware of. He has no adult history that I'm aware of. These are the only two cases that he's ever had any issues with. I agree, they're serious offenses. He understands that. He's told me today that, you know, if I could apologize to people, I would. He was encouraged by somebody older than him. I believe it was probably his father, who it was. And he's asking the court to give him probation. He would like to address the court, Judge.
Go ahead.
No, I apologize for all my actions, ma'am. Honestly, I regret them. I really do, ma'am. Like my attorney said, if I had a chance to apologize to that woman, I would. And ma'am, those write-ups were while I was in maximum security, ma'am. I was not supposed to be in max. I was there because my shoulder popped out of place. And all of those offenses were like, really, some of them, like, certain ones I do not understand how they were just.
I'm a whole lot less worried about that than what you were doing when you were out.
But honestly, on that count, I do apologize to that woman and for everything that I've done, man. I regret it very much. It's not just words, they're really, like, you sit on my mind daily, man, honestly. And I really just feel like, you know, if I did this, my sentence was up.
I appreciate you saying that. I hope that you're sincere. No matter what happens today, you have an ability at your age to change your life and do better things. Unfortunately, I tend to believe that sometimes people are sorry because they got caught, not because really of what they did. I don't disagree with Mr. Parker that looks like your dad's the one that's encouraging you to go out and do this crap. But all that being said, 2 times within a month, hoodies, mask, gloves, a pistol, another gun that has some kind of, I don't even know what it's called.
Silencer.
No, it was the circle thing that has a bunch of,
Your magazine.
thank you, drum magazine.
Honestly, I don't know nothing about it. Like, I mean, like you said, I'm gonna be honest with you, man. It was my father, like, but I did not have no intentions on doing no crime when my father showed up, man. Honestly, I didn't know nothing about how to rob a store, to do nothing with a store, anything like that. So, like,
Well, you went all in, didn't you?
I did.
And Tara, I mean, y'all didn't just walk in and take it. You got to grab her. You got to pull her around. You got to show that you're a man. Somebody did. While the other, so that means you were the one holding the gun with the drum, because the one that had the pistol is the one that was pulling her around. Okay. At this time, I'm going to, Mr. Watts, find in each of your cases that you entered your pleas of guilty freely and voluntarily. In cause number 25, DCCR 1918, find sufficient evidence to find you guilty, and at this time find you guilty of aggravated robbery. Sentence you to a term of 17 years in the Institutional Division of the Texas Department of Corrections. There will be an affirmative finding of a deadly weapon in that case, and you will receive credit on it for any time that you've been in custody that the law gives you the right to receive. In clause number 26, DCCR 0946, also find sufficient evidence to find you guilty, and at this time find you guilty of aggravated robbery. Sentence you to a term of 17 years in the Institutional Division of the Texas Department of Corrections. You will also receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. There will also be an affirmative finding of a deadly weapon in that case as well. These cases will run concurrently, which means together at the same time. I'm handing you in each of your cases the trial court certification that shows these were agreements that I followed, and so you have waived your right to appeal. I also handed you a written admonishment regarding your ineligibility to possess a firearm or ammunition. Because of the judgments entered against you, you're ineligible under Texas law to possess a firearm or ammunition. Possession of a firearm or ammunition could lead to charges against you. If you have any questions about the laws that make you ineligible to possess a firearm or ammunition, or about how long that lasts, you can talk with Mr. Parker. Again, you're young. You're going to go to prison, obviously, for some amount of time. It's going to be up to you to do something different or not when you get out. All right, you can go back with the bailiff.
Thank you.
Thank you, Detective Jackson, for being here.
Thanks.
Mr. Rojas, you got Jaden Brantley.
Brantley, not inclined to, but if you get what I want to, yeah.
Good morning. Thanks for being patient.
Sure.
Not that you have a choice.
My suggestion would be 1 week you do the ABC and the next week do ZBA.
I've tried to do some backwards, every now and then. I don't know if you've noticed, but I have. This is, Mr. Nichols' case on a Jaden Brantley. Good morning, you're Jaden Brantley. And this is cause number 26, DCCR 0422. Mr. Brantley's charged with the first-degree felony offense of aggravated robbery from February 6th of 2026. And what that means, Mr. Brantley, is that if you go to trial and you're found guilty, the range of punishment would be between 5 years and up to 99 years or life in prison. Do you understand?
Yes.
And I have here on the tablet a plea bargain rejection that has your signature on it with Mr. Rojas that shows that the district attorney's office has made an offer if you wanted to enter a plea of guilty for a cap of 25 years in prison, which means you would be leaving your punishment up to me. And as long as I didn't give you more than 25 years, I could give you 25 years, I could give you less. It would all depend on the information that was brought to me at a sentencing hearing. You have every right to reject that offer and have your case set for trial. Let a jury decide. I just want to make sure you understand what the possible consequences are if you go to trial, what your options are if you wanted to plead guilty. Do you understand all of that?
Yes.
And do you want to reject that offer and have your case set for trial?
That's fine.
All right, we'll get it set for trial. Is there any reason, I know that is Mr. Nichols' case, but is there any reason to believe, is there anything outstanding or why that offer would change?
Looks like the media has been picked up, Judge, as per the offer, nothing to my knowledge.
So I do want to make sure you understand, Mr. Brantley, once I place your case on the trial docket, then it's expected to go to trial. If you change your mind later and want to enter a plea of guilty, it would be to something different than this. Do you understand?
Yes.
All right, and so Mr. Rojas has been appointed to represent you. He's one of the attorneys who handles a lot of cases for me as a court-appointed attorney. With your permission, I can release him and appoint another attorney who could begin preparation for trial a little quicker. Is that okay with you? All right, so Mr. Rojas, you're released. Mr. Brantley, I'll appoint someone today. They should be out to the jail to see you very soon to begin preparation for trial. All right, you can go back with the bailiff.
Yes, ma'am.
Thank you. Jimmy Couch, the Senate.
Jimmy Couch.
Mhm.
Morning, Your Honor.
Good morning, you're Jimmy Couch.
Yes, ma'am.
And this is cause number 26, DCCR 0328. Mr. Couch was previously in court, entered a plea of guilty to the lesser offense of a third-degree felony attempt to commit burglary of a habitation. I've received the pre-sentence report. Have you both had an opportunity to review the report?
We have ground.
I have, Judge.
Are there any additions? Excuse me, additions or corrections?
No additions or corrections, Judge, just comments whenever the judge would.
Okay. Anything, Ms. Malfino?
Judge, I would just like to clarify for the court that the offer of the attempt to commit was made based on my review of the facts. I think it was more appropriate to the facts of the case that it be an attempt. It was not an attempt, no pun intended, to lessen his culpability or anything of that nature. I just think that fit the facts better and was a more appropriate plea. Ask the court to take notice of the PSI and also for some very brief comments. If the court would find it helpful, I would like to call Mr. Couch's wife, ex-wife, Allison Couch, just to let the court know some things about how strongly she's going to ask the court for safety and the state's going to ask for safety in this case. And I think it would just help give you, if you
That's
feel like you
agreed
need-
though, right?
Safety was not agreed, Judge.
No, ma'am.
Not-
Oh, safe P's happening.
Ma'am?
If I give you probation, then safe P is going to be a condition of that probation. End of
Yeah, ma'am.
story. So, I mean, either here's the thing, Mr. Couch, conditions of probation
Yes,
are
ma'am.
up to the court, 100%.
Okay.
So even if that had not been part of your agreement, it doesn't invalidate your agreement because I can impose any conditions that I think would be either helpful or necessary to make sure that everybody that's on a probation has the best possible chance of success and that everybody else out there is safe and secure as we can make them. And so if I follow this agreement, it is going to be with SAP based on, I've got the her statements, and thank you for being here, ma'am. I've got the statements she has here, and I appreciate that she's here in person as well. That means a lot. If there's something that's not in here, we'll take judicial notice of her statements as well as the probation reports statements with regard to substance abuse history and the fact that they believe that he needs substance abuse help, but he does not.
Do I get to make a statement?
Sure.
Your Honor, I don't do drugs. I haven't done drugs since I was a stupid kid, 20 years old. I don't do any drugs whatsoever.
Well, it's not just about drugs, it's about alcohol as well.
And I don't have an alcohol problem, Your Honor. I might drink a beer or two a week. That's it. I don't have any alcohol problem. I mean, I don't understand. I've already lost 6 months of my life and I have serious lung disease that I have to have another PET scan and another biopsy because Mr. Spot on my lungs are growing. I've coughed up blood 4 times in the last 3 months, been in jail. They will not give me my medications or my lung
Well,
treatment.
maybe you shouldn't have gone and committed this offense.
Your Honor,
Hang on, listen.
I
Okay, just
apologize.
hang on. I understand some medical issues.
Mhm.
But that's not what's going to go into completely any decision that I make. Okay, so just hang on a second.
Okay.
Mr. Rojas,
Judge, I would just point out that at least from his, whatever he self-reported to the probation department, looks like the last time he used any drugs was 2023, and that he tells me that was prescribed from a surgery he had.
Yeah, that's my surgery.
And the last time he used alcohol was August of 2025, and he was out on bond until June of this year. So if that's true, it would tend to show that he didn't have an alcohol problem.
if your witness is willing to come testify under oath, then that would be probably good.
Thank you, Judge. Ms. Couch. Maiden name, Byron.
Okay. Good. Do I?
Don't interrupt.
Okay.
Good morning, ma'am.
Good morning.
If you'll please raise your right hand. Do you swear or affirm the testimony you're going to give in this hearing will be the truth, the whole truth, and nothing but the truth?
Yes, I do.
Thank you. Ms. Malfino.
Ms. Couch, would you please state your full legal name for the record, please?
Allison Couch.
And how do you know the defendant, Jimmy Couch?
He's my ex-husband.
Okay, and you tell the court, you are aware that we're here for a sentencing hearing today, correct? And is it correct that you and I have kept in pretty constant communication with respect to this offense? And you filled me in on a lot about the defendant, his history, his substance abuse history that may not be included just with respect to this offense,
That's
correct?
correct.
And do you think it would be helpful to Judge West to hear just a very little bit about that, especially after you've seen how the defendant has acted this morning, which was obviously a concern of all of ours, correct? That he continues to minimize, he distances himself from the severity of his alcoholism or substance abuse problem. Would you think?
He's mildly.
Look at me. You turn to, actually do this. Turn around and look at that wall. Go ahead, ma'am.
I'm sorry, Judge. Do you think it would be helpful for the court, from your perspective, to know just a little bit more about Mr. Couch and what you want for him with respect to his trying to get help, and why you and I discussed at length this offer and a chance at probation to try to get him the substance abuse help?
The whole point in this and me sticking this through is to get him the help he needs. He's a serious, serious alcoholic. His family knows it. His friends know it. I lived with it. It's terrible. And we love him, but we want him to get well. He hasn't been able to do it on his own. And this is our last resort, is basically what this is.
It's either this or prison, right?
Yes.
And
Or he'll kill somebody while he's out there driving drunk.
do you believe this with everything you know about the defendant?
Everything. I've experienced a lot with Jimmy. It's been a very hard experience. But I do have a lot of love and heart and care for him in my heart to see him through this. I want to see him get help.
And is that in fact why you are asking the court to consider allowing him to serve this probation, but imposing safety, which we have discussed is the most stringent lockdown treatment program with all of the aftercare conditions, et cetera, with a condition that afterwards he have no contact with you? I know we had discussed some things with concern to his sister's concerned she may come there, you're concerned he may come to you. And he's got to learn how to stand on his own 2 feet and not bring his problems back into everyone else's life. You're asking Joe to do that.
Well, we do know that he has nowhere to live. He has nowhere to go. The family knows what's going on. Nobody can take him at this point. But we don't want to see him not have communication with family. We feel like that's part of the healing that he's going to go through. But we do feel that he's going to have to be forced to do this because he has failed on his own prior to this. He didn't complete a rehab he did before. And it's just it hasn't stopped.
Thank you. Any questions, Mr. Rojas?
Man, what?
Sorry.
When was that rehab?
It was 2 years ago.
And you guys were still married at that time?
Yes.
And when's the last time you actually saw him take a drink?
Right. He was drunk when he came to my house and got arrested. Yeah, he's been drinking up until he got arrested.
And that was in January.
Yes.
Pass the witness, Judge.
Right. Thank you very much, ma'am.
Can I turn that?
I'm standing right here.
I'll get-
Any other witnesses?
There you are.
No,
All right.
Can I call my witness?
No, you have an attorney. Mr. Couch, what you're doing today is giving me more and more concern about whether or not I should even follow this agreement. You are interrupting, you are denying everything. In fact, I already had a mark in this pre-sentence report that you pretty much your version of the offense is not what the official version is, and it's not accepting responsibility. Flat out not accepting responsibility. So if I'm going to go along with this agreement, it is going to be with help, whether you think you need it or not. So at this time, in cause number 26, DCCR 0328, going to find that you entered your plea of guilty freely and voluntarily. find sufficient evidence to find you guilty, but I'm going to follow the agreement and defer all proceedings and place you on probation for 3 years. You're ordered to pay a $500 fine and to follow all of the rules and conditions of probation. That is going to include entering and successfully completing the safety program. You have, it sounds like, people who love you and care about you and want you to do better. It's going to be up to you to do that. Part of your probation is going to be to have for sure, no in-person contact with Allison Couch. If there is at the time through probation that communication is helpful and positive, then I would allow that, but that's going to be through probation and through your family and or Ms. Couch reaching out to them and saying that that's okay. I'm handing you the trial court certification that shows this was an agreement that I followed, and so you've waived your right to appeal. I hope you take advantage of this, Mr. Couch.
Ma'am, can I make one more statement, please?
What's that?
She got all my property. She's got all my property, my IDs and everything. I can't even get money out of the bank or anything, but she has all my property. Can I have a week or something to get my truck out of the tow yard and I'm gonna lose my truck?
No,
my
I'm
business?
sure it sounds like there's people that will help with that.
There
Talk to
is-
Mr.
there is no
Rojas.
one, Your Honor. There is no one.
Well,
I can't even make a phone
I'm not
call.
gonna let you out. All right, you can go back with the bailiff.
How do I do that?
That's what she was feeling.
Corbin Rayleigh, Mr. Rojas, is she sentencing?
Rating.
Let's see. Oh, and there's another one. You have one with Miss Burge? Okay, I'll take care of it.
And the last one was Troy Wiseman. We're gonna ask for refit on that one, because Pam and I are gonna talk about some other stuff.
Okay, so we're gonna reset Mr. Wizenant. Let's give y'all some time to visit on that one.
We'll talk about.
Yeah.
Yeah.
It's normal reason.
I can.
Morning. We're going on 3.
His two
There's also
TRPs.
business.
Oh, 2 of them are MTRPs.
Yes.
Please, the 2 MTRPs would be great.
Yes.
Which one are you printing on? 3 years deferred? I didn't. 3 years deferred.
You didn't say.
Okay,
Say it.
let's see, it's on. Which one are you printing?
The 19. I 24.
Okay. Just to say, that's okay, I'll print this. All right, and Ms. Burge was previously sworn in to translate for us. Ms. Holmes, will your client waive the formal reading of the indictment and the motion?
Yes, Your Honor.
Sir, are you Martin Fonseca Cardenas?
Yes. Yes.
Mr. Fonseca Cardenas, in cause number 26, DCCR 0619, you're charged with the 3rd-degree felony of harassment of a public servant from March 19th of 2026. And how do you plead to that charge?
Guilty.
Are you pleading guilty freely and voluntarily?
Yeah.
Yes.
And are you pleading guilty because you actually did what they've charged you with?
Yes.
In that case, I have here on the tablet some documents that have your signature on them that the state's marked as Exhibit 1. Before you sign these, did you go over them with Ms. Holmes and the interpreter?
Yes.
Do you fully understand them?
Yes.
And do you understand if I follow the agreement that you've made, that you'll be waiving any right to appeal?
Okay.
State tenders number 1,
No objection.
it's admitted. Is there any evidence that Mr. Fonseca Cardenas is not competent?
No, Your Honor.
All right, sir, in cause number 260619, I'm going to find that you entered your plea of guilty freely and voluntarily, find that you're mentally competent, and understand the nature and the consequences of your plea. And also, before I go forward, do you also understand, sir, if you're not a U.S. citizen, that a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law?
Yes.
Then at this time, I'm going to find sufficient evidence to find you guilty and find you guilty of harassment of a public servant, sentence you in accordance with your agreement to a term of 4 years in prison. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. And then we have, go ahead.
He's asking if the 6 months are gonna be included.
Yeah, he's been in custody since February.
Yes. So then I have cause number 231824 and 231825 in. Should they both be first amended, or is there one that's?
They both, yeah, but they're both first.
Pull the right one up.
Yeah.
They're both first.
Let me print out the correct one. In 1824, I have a first amended motion to revoke your probation. Shows that you were placed on probation February 6th of 2024 for evading arrest or detention with the use of a vehicle. And that was a 10-year term in prison that was probated for 10 years. Is that correct?
Yeah.
I believe,
Yeah.
but that may be a typo, Judge. It looks like one of my files showed that he pled for 10 years probated for 5, not 10 probated for 10.
10 over 10? Okay. And then in cause number 1825, I also have a first amended motion to revoke your community supervision. Shows that you were placed on probation February 6th of 2024 for the state jail felony of unauthorized use of a motor vehicle. And that was a 2-year term in state jail that was probated for 5 years. Is that correct?
Yes.
Each of these motions allege that you violated your probation. Would the state mind narrowing down since there's an agreement?
Yes, Judge.
Which one's the offense we just took care
I
of?
think the March 19th one, so it's 5.
On 824, It's gonna be 5.
Okay, the March 19th date on both of them.
Yes, Judge.
All right, sir, in 1824, count 5 in that motion alleges that you violated your probation by committing that new offense of harassment of a public servant, March 19th of 2026, that we just talked about in the other case. And is that true or not true?
Yes.
True or not true?
¿Cierto o no cierto? Tiene que decir cierto o no cierto. True.
Thank you. And then in 1825, the state has elected to proceed on count 7.
Y vamos a hacerlo con el número 7.
It also alleges that you violated your probation by committing the new offense of harassment of a public servant, March 19th of 2026.
Marzo del 2026.
And is that true or not true?
No cierto. ¿Cierto o no cierto? True.
Did you enter your plea of true to each of those counts freely and voluntarily?
Obviamente. Yes.
In both of those cases, I also have here on the tablet some documents that have your signature on them. Did you also go over these with Ms. Holmes and the interpreter?
Papeleo que firmó conmigo también. Yes.
Do you fully understand those also?
¿Dónde el papeleo que firmé? Yes.
And do you understand if I follow the agreements that you've made with the district attorney that you'll be waiving or giving up any right to appeal?
Yes.
State tenders number 1 in each of those cases.
No objection.
It's admitted in each case. Any, is
Ahorita.
there a question?
He's asking if you can send him to a different prison.
No,
Dice que no.
it's not up to me.
Dice no es la decisión mía.
It's up to the prison authorities.
Es la decisión de los oficiales en la prisión.
Okay. So in cause number 23, DCCR 1824, I'm going to find that you entered your plea of true to count 5 freely and voluntarily. Find that count true. Find sufficient evidence to revoke your probation. And at this time, revoke your probation, reassess your punishment to a term of 4 years in the institutional division of the Texas Department of Corrections. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. And then in cause number 1825, find count 7 true. Find that you sufficient evidence to revoke your probation. And at this time, revoke your probation, reassess your punishment in accordance with your agreement to a term of 18 months in the state jail prison. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. These 3 cases will run concurrently, which means together at the same time. I'm going to sign a dismissal as part of this agreement in cause number 26, DCCR 0620. And then the state will get dismissals in your 2 misdemeanor cases, 26, 1097 and 1098. I'm handing you in these cases the certifications that shows these were agreements that I followed, so you waived your right to appeal. I also handed you an admonishment in Spanish regarding your ineligibility to possess a firearm or ammunition. Because of the judgments entered against you, you're ineligible under Texas law to possess a firearm or ammunition. If you have questions about those laws, you can talk to Ms. Holmes. Okay, good luck to you, sir. You can go back with the bailiff. Thank you, Ms. Burge.
Thank you.
Thank you, Judge. Thank you.
Yes, sir. Douglas Miles,
He's not here.
He was here on a bench warrant when I did the docket, he wasn't in custody, so I didn't bring in.
Okay. Okay, all right. And then Bryson Parkerson,
Yes, you may not. You,
yes, ma'am. Yes, ma'am. Frederick Bruno.
bro,
Like this has been a long morning.
Week this morning.
It has been a long week in one day, seems like. All right, sir, you're Frederick Bruno. And this is cause number 20-35302. Mr. Bruno is on probation for the third-degree felony offense of assault on a family member by impeding breath or circulation, and that probation was from November 30th of 2020. It was a 10-year term in prison that was probated for 10 years. There's been a first amended motion to revoke community supervision filed. Allegations allege an evading arrest or detention with the use of a vehicle from April of 2026, possession of a controlled substance from April of 2026, failure to report arrest from that April 26, possession of a drug, synthetic marijuana on that same date, behind in court assessed fees. Then it goes on that there was another offense of possession of a controlled substance, July 24th of 2026, two on that same date, possession of a controlled substance. Also a failure to report to probation, April 28th, May 28th, and June 17th of 2026. Ms. Holmes has filed a motion asking that I set a bond in Mr. Bruno's case. It is a straight probation. Ms. Holmes, do you wish to call your client as a witness?
yes, Your Honor.
Sir, best you can, raise your right hand. Do you swear or affirm the testimony you're going to give in this hearing will be the truth, the whole truth, and nothing but the truth? Thank you. Go ahead, Ms. Holmes, and be sure you speak up so I can hear you and the court reporter can hear you.
Could you state your name for the record?
Richard Sam Bruno.
Okay, and Mr. Bruno, how long have you been housed at the Jefferson County Jail?
Since 24th of last month.
Okay, so almost a month.
Mhm.
Okay, and since then you have not had a bond set in regards to your case. That's a motion to revoke probation, correct?
Correct.
Okay, now you've heard the judge go over the allegations in which they've stated you violated probation, correct? Okay. Are you asking that a bond be set while this motion is pending?
Yes.
And if the judge sets a bond, are you willing to abide by any conditions such as drug patch or GPS monitoring to ensure that there are no further violations or allegations?
Yes.
If you were to be given a bond, where would you be residing?
4493 Harding Drive.
Okay, and is
Say it
that
again.
4493 Harding Drive.
Go ahead, sir.
yes, ma'am. And is that in Beaumont?
Yes.
Okay, and who lives at that address?
But
Okay, okay, and so you would be residing with your mother if you're able to be granted a bond. Okay.
Be sure you say yes or no.
Yes.
Thank you.
Okay, and is there anything additional that you would like the court to know?
and I'm ashamed.
Just, we'll get to, but just in regards to the bond, if you were granted a bond, will you abide by any conditions? You gotta say yes or no. Okay. Okay, I'll pass the lead, Sharon.
Mr. Smith, any questions of the witness? So I'm just going back. It looks like as part of Mr. Bruno's probation, he was placed on probation in 2020, but then there was some issues apparently in 2022 where he was continued on probation, but ordered to enter and successfully complete the safety program as part of probation. And it's like, I guess he did that. And then we're here with all of these allegations with regard to possession and some drug issues and things like that. I have taken judicial notice or am taking judicial notice of the court's file. It does include within my file with the administrative hearing this time, the probable cause affidavit, with regard to the new, possession offenses, from this year in April. Anything else? Miss Holmes, you may go forward with, argument.
Yeah, Sharon, I do understand, obviously, these are serious allegations that I've gone over with Mr. Bruno. We are asking that if a reasonable bond be set, so that he could try to get back on track. And obviously, because of the allegations, with, substance issues, we know that it would be in his best interest if he is granted a bond, that it be monitored via drug patch or something to that nature, just to make sure that, he stays on the right track. In addition to GPS monitoring, he says he will abide by that as well. If there's any fear of absconding, because we do know that that was an allegation as well.
Mr. Smith?
Judge, state's opposed to a bond. He committed a new felony offense in April. We filed a motion in May. He got out of jail in April. Committed a new offense in July. We had to amend our motion that was already pending, and here we are again. I just don't feel like bond is appropriate for this defendant.
So it looks like there was I've got the timeline. There was an administrative hearing from April 21st, which had the allegations from the traffic stop from April 16th of this year, which resulted, it says, in a brief pursuit, and then after that, that was, the defendant was found in possession of multiple baggies containing synthetic marijuana, charged with evading and possession on that date. He was released the 19th, so 3 days later. Then we get to the second, so a month and a half, 2 months later, on July 24th, 2026, Mr. Bruno's arrested at an abandoned structure on Magnolia, alleged to have also digital scale, sandwich baggies, all that kind of stuff as well, which resulted in the 2 new cases. The fact that you were that you're on a felony probation, that you were arrested, were able to get out before that motion was filed, and then have now been arrested again for new offenses. I'm going to find that it is in the best interest of our community, and I'm going to deny any bond in this case. I will set the case for an announcement, and we'll see where we get.
Yeah.
Right, and you go back with the bailiff.
Okay.
Okay. Right, y'all can come on up. This is Louisa Magruder. Good morning, ma'am. You're Louisa Magruder. And we're here in cause number 16-25158. We were previously here some time ago. Ms. Magruder is on probation. There's a motion to adjudicate or revoke her unadjudicated probation that was filed. There were pleas of not true that were entered, and this was reset for a sentencing hearing today. I have the updated pre-sentence report. It's my understanding, however, that you guys have now reached an agreement and that Ms. Magruder intends to change her pleas in that motion. Is that correct?
That's
All right. Will she waive the formal reading of the motion?
Yeah, we'll wait.
So, Ms. Magruder, we already went through this motion, but because there's going to be a change of plea to some of those allegations, I'm going to go back through it with you, okay? So, I have a motion to revoke your unadjudicated probation. It shows you were placed on probation January 29th of 2018 for the second-degree felony offense of sexual assault of a child, and that was a 10-year deferred probation. Is that correct? It alleges that you violated your probation. Count 1 alleges that you failed to report as directed to the probation department May 23rd and June 2nd of 2025. And is that true or not true?
True.
Count 2 alleges that you failed to work faithfully at suitable employment and provide verification of that. And is that true or not true? Count 3 alleges that you did not submit to alcohol or drug screening June 2nd, May 28th, and May 19th of 2025. And is that true or not true? I'm sorry.
True.
Thank you. Count 4 alleges you're behind in your court assessed fees. Is that true or not true?
True.
And then count 5 alleges that you did not enter and successfully complete the Jefferson County Drug Intervention Program, the JCDI program. Is that true or not true?
True.
All right. Did you enter your pleas of true now to counts 1 through 5 freely and voluntarily?
Yes, ma'am.
And because they're actually true.
Yes, ma'am.
I have here on the tablet some documents that have your signature on them with your attorneys that the state has marked as exhibit number 1. Before you signed these, did you go over them with Mr. Bynum?
Yes, ma'am.
Do you fully understand them?
Yes, ma'am.
And do you understand if I follow the agreement that you've made with the district attorney that you'll be waiving or giving up any right to appeal?
Yes, ma'am.
State tenders number 1.
No objection.
It's admitted. Is there any evidence Ms. Magruder's not competent?
No.
All right, Ms. Magruder, then at this time, I'm going to find that you entered your pleas of true to counts 1 through 5 freely and voluntarily. Find those counts true. Find sufficient evidence at this time to find you guilty, and at this time find you guilty of sexual assault of a child. Sentence you in accordance with your agreement to a term of 9 years in the institutional division of the Texas Department of Corrections. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. I'm going to hand you the trial court certification that shows this was an agreement that I followed, and so you've waived your right to appeal. Also have handed you a written admonishment regarding your ineligibility to possess a firearm or ammunition. Because of the judgment entered against you, you're ineligible under Texas law to possess a firearm or ammunition. Possession of a firearm or ammunition could lead to charges against you. If you have any questions about the laws that make you ineligible to possess a firearm or ammunition, or about how long that lasts, you can talk with Mr. Bynum. And we went over way back when you first got this probation, also the sex offender registration. You've already signed that and understand that that's part of this case as well.
Yes.
Okay, good luck to you, ma'am. Thank you all for working it out. Thank you for being here, Ms. Becker.
It's just brief, it's not.
Okay.
I said, I wrote it 10/5/25. I said, I want to first start off by saying I thank you for giving me a chance and seeing in me what I can't say in myself. I remember what you told me the last time I came to court, and my mind or heart isn't set on going home today. But the Lord just placed me in my heart to tell you thank you for being you. I will do my best to make sure I'm being a better person while in jail. I just want to thank you, y'all.
Thank you for that. Good luck to you. I really do wish you the best.
Thank you.
Okay. Good morning. Good morning, sir. You're Juan Sanchez. And this is cause number 18-30854. We've got a motion to revoke probation. I guess set for an announcement. Were y'all, before we go any further, were y'all able to work out getting everything discovery wise, that anything that was an issue?
Yes, Your Honor, we've received discovery and I've reviewed it.
Okay, perfect. And so what is the announcement?
We're ready to proceed.
Okay, and so there's no agreement?
We haven't really discussed that. I don't think he's going to accept any revocation offer, Your Honor.
All right, so what we can do is just go through that motion, get pleas of true or not true, and then we would reset it for a hearing on sentencing, get a pre-sentence report update done. Does that sound like what we need to do?
I think so, Your Honor.
All right, let me get this.
Yes, Your Honor, he does want to stay. I just checked with him this morning again. He wants to stay on probation.
All right, so we'll go through that motion. Let me get it pulled up the right way. Mr. Sanchez, the best you can, raise your right hand, please. Do you swear or affirm the testimony you're going to give in this hearing will be the truth, the whole truth, and nothing but the truth? Speak up, please.
Yes, Honor.
Thank you. And will he waive the formal reading of that motion?
Yes, Your Honor.
Let's see. All right, Mr. Sanchez, I have a motion to revoke your community supervision. Shows that you were placed on probation September 30th of 2019 for the offense of driving while intoxicated, a third-degree felony. That was an 8-year sentence in prison, but it was probated for 10 years. Is that correct? I need everyone to please hold it down. If you're talking to a DA, that's fine. Everyone else. Mr. Sanchez, is that correct? Okay. Thank you. Count 1 in this motion alleges that you violated your probation by committing the new offense of driving while intoxicated, third or more, April 15th of 2025 in Wharton County, Texas. And is that true or not true?
Yes, Honor.
That's true? Okay. Count 2 alleges that you failed to provide verification of having the auto ignition interlock system on your vehicle. Is that true or not true?
Yes.
It's true. And then count 3 alleges that you failed to never become intoxicated or under the influence of an intoxicating substance, and that you were intoxicated April 15th of 2025. Is that true or not true? It's true. Did you enter your pleas of true to counts 1, 2, and 3 freely and voluntarily? Okay. And did you plead true to those counts because they're all actually true?
Yes.
Okay. I'm going to find that you entered your pleas of true to counts 1, 2, and 3 freely and voluntarily. Find those counts true. Find sufficient evidence to revoke your probation, but I'm not going to do that today. I'm going to reset your case so that the probation department can do an updated report, give me more information about what's been going on probation and all of that. And then we'll come back at a later date for sentencing. If there's anything that you think is important for me to know, get that information to Mr. Franklin and he will present it to me on your behalf when we come back. Do you anticipate any witnesses or anything?
Pleaded true, Judge. I'll just wait and see what the report has to say.
Okay, sounds good. We'll reset it for sentencing. Thank you.
Thank you, Your Honor.
We need to get his fingerprint while he's here, please. Unagreed, yes, ma'am. Yes, thank you. Let's see, is Mr. LaGroppe here? LaGroppe? On Courtney Joseph? Courtney Joseph. Good morning, sir. Say, how do you pronounce it? LaGroppe or LaGroppe? LaGroppe, okay. I was right the first time.
I recognize you were in here, I think.
I've been in this court.
We've been here for,
Yeah, it's been like 7 or 8 years since I've been here now. This time it's not a family member. That's so much fun.
oh,
It's my brother. They
feel like,
dismissed.
now I feel like I
Money to
remember.
get it dismissed.
I feel like I remember some vague memory of that.
And I didn't know if you knew a bunch of you knew some of my cousins. See, all my whole family's in Port Arthur.
Oh, are they?
Yeah, they all went to TJ.
Oh, yeah.
My uncle, Wesley J.
My husband went to TJ.
He coached, he was principal and Bum Phillips was the coach.
Oh,
30 years. So I had 15 biological uncles.
oh. That's okay.
Cajuns.
Okay, as soon as she's on the other side, they'll walk her down. As soon as they get her down, we'll take care of this. And this is just a bond hearing for the motion, right? All right. Oh, never mind. Come on back. Let's see. Pull this up.
Oh, cool.
All right, this is cause number 23 DCCR 0167. And are you Courtney Joseph? And so Ms. Joseph is on probation for assault on a peace officer. That probation started on December 11th of 2023. It was a 5-year deferred probation. A motion to revoke that probation has been filed with allegation of driving while intoxicated with a child passenger. I guess there must have been at least 3 of those passengers because there's 3 charges. Violation of committing the offense of resisting arrest. Allegedly left the county and was in Orange without permission. Out past court-ordered curfew. The new offenses alleged were at 10:17 p.m. in Orange, it looks like, yeah. And behind on fees. And Mr. LaGroppe has filed a motion asking that I set a bond. It is a deferred probation, so typically a bond would be set depending on certain circumstances. So Mr. LaGroppe, I will go ahead and let you want to call your client, or if you would, ma'am, best you can, raise your right hand. Do you swear or affirm the testimony you're going to give in this hearing will be the truth, the whole truth, and nothing but the truth? Thank you.
And I'm just going to question her about her financial circumstances.
That's fine.
Okay, how long have you lived in Jefferson County?
Since 22.
Speak up some for me and for the court reporter, please.
August 2022.
Okay.
Where did you live before that?
In Orange, Texas.
How long did you live in Orange, Texas?
Almost 2 years with my grandmother
And where did you live before you lived in Orange, Texas?
in Port Arthur
Port Arthur. How long did you live in Port Arthur?
for 3 years.
Let me ask you this, where were you born and raised?
Orange, Texas.
So you lived in the general area of Jefferson County, Orange, Texas, and Port Arthur since you were born, huh?
Yes.
Okay. Have you ever moved out of state or anything like that?
No.
How many children do you have?
Yeah, 5.
And where do they all live?
With me.
What type of work were you doing when you were on probation?
I was in care provider.
Care provider. Explain to the judge what you mean by care provider.
I provided for elderly man. I cook, clean, 3 hours a day, 5 days a week.
How much money were you making with that?
Just $8 an hour.
How much money approximately would you make a week?
How much export? So like 140.
And so you make about $140 a week?
Yes.
So you would total about $600-700 a month?
Yeah.
Okay. Where do you and your children live?
On 8th Street.
Do you live with your family or do you live by yourself?
Me and my children, my mom just moved back in.
So your mother just moved back?
Yes.
Before the allegations that are alleged in the motion to revoke probation, who were you living with at that time?
Just me and my children.
Okay. You and your sisters?
Me and my children.
You and your children. If you're only making $600 a month, how are you paying rent where you live?
I also get Social Security survivors. My children's father that passed into me.
And how much money do you get for survivors?
$780.
$780 a month. Okay. And approximately how much money do you have right now? No? Okay.
Speak up.
I get paid around the 15.
How much money will be coming in?
$780.
Okay. And so if the court were to set bond at a reasonable amount, okay, would you show up for your court appearances?
Yes.
Okay. You understand the allegations against you, right?
Yes.
Okay. And you're gonna have to appear in Orange County, correct? What's the county of Orange? I can't-
Orange. Mhm. It is.
I should know that. Orange County. So what was your bond set out in Orange County?
3.
3 what?
3,000.
Okay, 3,000. So, and did you post that bond?
Yes.
Okay. Have you had to show up for court yet for that yet?
No,
When is your next court appearance for that?
I have no idea. I was calling every Monday as I was supposed to, and then when this one came in, I turned myself in.
Okay. And you did turn, once you found out, you talked to your probation officer, they told you they were gonna file a motion to reopen, right?
Yes,
And you reached out to me, correct?
yes,
And then you turned, and they had to schedule a meeting for, I think it's July 31st,
the 31st, 49 o'clock.
and you turned yourself in the day before,
Yes,
correct? And you knew you were gonna be arrested if you came.
I'm pretty sure.
Okay, I pass on.
Any
I have
questions?
no other questions for purposes of this hearing. Your
All
Honor.
right, any other witnesses?
No.
Mr. Nichols, what's the state's position on
I don't mind
this?
the court setting a reasonable bond in this case, Your Honor. I just want there to be sufficient conditions in place to keep her from driving, and she needs to have an alcohol monitor of some sort. I'll note, all these violations except for the fees and stuff, all of one incident, there's not a history of testing positive or anything like that. So whatever the court sets is fine, as long as we have those restrictions that we need.
Okay.
Can I elaborate?
Yes, sir, please.
Very minor amount. Her mistake was she went to a family gathering. That's why she left the county. That's why she left to go to a family gathering with all of her children. That's wherein the rub lies. Bad judgment, Your Honor.
Very, especially while you're on probation for a second-degree felony. So what I'm going to do is grant the motion. I'm going to, is there an order? I'm going to,
I'll follow.
okay. Let me look at one thing real quick. I'm going to set your bond at $20,000. A condition of that bond, if you make it, will be that you will be required to wear a scram device. And that is a monitor that you wear on your body at all times that will alert if any alcohol is consumed at all. Obviously, you will be ordered to remain in Jefferson County, Texas. Just like before, if you leave Jefferson County for any reason without permission, your bond, we're not going to be talking about a bond again. You'll just be sitting in jail waiting on all of this. Do you understand?
Yes.
If you test positive for alcohol, then you're going to end up right back in here. Do you understand that? Anything else?
I think that's sufficient.
All right. Well, if we'll reset it for a regular announcement and see where we get at that point. All right.
I'll try.
Okay. Thank you, sir.
Orders.
Thank you. Mr. LeGras, if you want to just email the order.
Thanks. That's so very nice.
Mr. Macon, you've got Ronald Spites.
Yes, Your Honor, it's a bond.
Everybody wants to get out of jail.
Yeah. Good morning, Your Honor.
Good morning. How are you?
Well, yesterday I spent all day in Houston with doctors, so I'm glad to be here.
We're glad you're here.
But, as I've said before, getting old is not for young people.
Good morning. Are you Ronald Spites? And Mr. Spites is charged with the offense of manslaughter in cause number 25 DCCR 0920. Mr. Macon has filed a motion asking me.
No, he was arrested for murder and indicted him for manslaughter.
Potentially knowingly causing the death of an individual.
Let me look at the indictment. It shows. I don't know why the heading
Heading says manslaughter, but the language.
did then and there
Intentionally,
intentionally and knowingly caused the death of an individual, namely Rowan Williams, by striking him with an automobile. So at least on the indictment language, that would be murder. I know it's not, the headings are not sometimes important, but I think that needs to be adjusted and changed, especially if that is what is in, that's what's in Odyssey. So that's showing up on everything with the wrong stuff. So that needs to be amended if you can. Take care of that later. So based on that, it looks like the offense is actually the first degree felony offense of murder, Mr. Spites. And Mr. Macon has filed a motion asking that I reduce your bond. Did I print? No, I'm printing it now, the PC. Bond is currently set. Sorry, I've got too many things I'm thinking about trying to do right now.
It's $800,000.
Thank you. Currently set at 800,000. Mr. Macon, do you wish to call your client?
Yes, Your Honor.
Sir, if you'll please raise your right hand the best you can. Do you swear or affirm the testimony you're going to give in this hearing will be the truth, the whole truth, and nothing but the truth? Thank you. Go ahead, Mr. Macon.
Now, what's your name?
Ron James Spike.
And Mr. Spikes, you're the person charged with the offense.
Yes, sir.
Do you have enough money, you or your family, to post a $800,000 bond?
No, sir.
Okay. Now, before you were arrested, I mean, in the past, you were in lots of trouble, right? And you've got some priors, but in the last 10 years, have you been in any trouble?
No, sir, I have not been in no trouble.
Okay. And you have your wife living in this area?
Yes, I have my wife, my family.
Okay, and your family, and you have a job, were you able to make funds?
Yes, sir.
And that's with your father-in-law, Mr. Gonzalez,
Yes,
correct?
sir.
And that's at 365 Scrap?
No, yes, sir.
Okay, and did you also work for Zachary as a heavy equipment?
Yes, sir, I do.
So you've always been working and all?
Yes, I have.
Do you have any assets whatsoever? Real property, coin collection,
No, sir.
anything like that? Then you're asking the court to set some reasonable bonds so you could get out and go to work?
Yes, sir.
Mr. Smith, any questions? All right, any other witnesses?
No.
Mr. Smith, what is the state's position?
Judge, he does have a prior from 1998, and so 4 years GEC. So whatever it's murder, he would be 15 to life at least. And if it's manslaughter, it's about state is reasonable for us.
Mr. Macon?
Your Honor, we think that $800,000 bond is excessive and would ask that it be lowered.
I am taking judicial notice of the court's file, which includes the probable cause affidavit, as well as there was a letter of support that was sent by Mr. Macon from a Rocky Johnson. Were you able to review that, Mr. Smith? I think it was emailed.
I believe it.
Okay. Can you take a look at this real quick? And the prior was from when? 90?
98. November 16th.
Okay. Speak up, please.
It was from November 16th of 1998, 4-year sentence.
All right, 2, possession of controlled substance, same date. Got it. Okay. What I'm going to do is I am going to grant the motion for a bond reduction. I'm going to reduce the bond to $500,000. Sir, did you want to say that again louder? You did say something.
Well, I didn't say nothing to him.
I'm going to reduce the bond to $500,000. A condition of that bond would be, if you make it, that you are on house arrest and required to wear a GPS monitoring device at all times. And we will get the case set for an announcement as quickly as possible. All right, sir? That's what it's set at right now. All right, you can go back with the bailiff. What?
I'll be back.
Ms. Perazzo, you have LaCaven Jenkins. Good morning. Is he pleading to the indictment as it is, or is there any?
As is.
Thank you.
Mr. Sorry. Philip said that the discovery exhibit for one of those is being sent by Sarah since I didn't have it.
Okay, thank you. Thank you, Mr. Smith.
Sorry.
All right, are you LaCaven Jenkins?
Yes, ma'am.
And Ms. Perazzo, will your client waive the formal reading of the indictment in each case? Mr. Jenkins, in cause number 24, DCCR 1026, you're charged with a first-degree felony offense of aggravated robbery, and that is from March 3rd of 2024. And how do you plead to that charge?
Guilty.
Are you pleading guilty freely and voluntarily?
Yes, ma'am.
And are you pleading guilty because you actually did what they charged you with?
Yes, ma'am.
And then in cause number 24, DCCR 1027, you're charged with a third-degree felony offense of fraudulent use or possession of identifying information from March 12th of 2024. And how do you plead to that charge?
Guilty.
Again, are you pleading guilty freely and voluntarily? Answer out loud for me, thank you. And are you pleading guilty because you actually did what they charged you with?
Yes, ma'am.
I have here on the computer some documents in each of those cases that have your signature on them that the state has marked as exhibit number 1. Before you signed these, did you go over them with Ms. Perazzo?
Yes, ma'am.
And do you fully understand them?
Yes, ma'am.
And do you understand, if I follow the agreement that you've made with the district attorney, that you will be waiving or giving up any right to appeal?
Yes, ma'am.
Also, do you understand, if you're not a U.S. citizen, that a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law? State tenders number 1 in each case.
No objection.
It's admitted in each case. Is there any evidence that Mr. Jenkins is not competent?
No, Your Honor.
All right, sir, I'm going to find that you entered your pleas of guilty in each case freely and voluntarily. Find that you're mentally competent and you understand the nature and the consequences of those pleas. In cause number 24, DCCR 1026, find sufficient evidence to find you guilty, and at this time, find you guilty of aggravated robbery. Sentence you in accordance with your agreement to a term of 8 years in the institutional division of the Texas Department of Corrections. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. Is there a, I am making an affirmative finding of a deadly weapon in that case. And then in cause number 24, DCCR 1027, also find sufficient evidence to find you guilty. And at this time, find you guilty of fraudulent use or possession of identifying information. Sentence you in accordance with your agreement to a term of 5 years in the institutional division of the Texas Department of Corrections. You will also receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. These cases will run concurrently, which means together at the same time. I'm going to hand you in each of your cases, the trial court certifications that shows these were agreements that I followed. And so you waived your right to appeal. I'm also going to hand you a written admonishment regarding your ineligibility to possess a firearm or ammunition. Because of the judgments entered against you, you're ineligible under Texas law to possess a firearm or ammunition. Possession of a firearm or ammunition could lead to charges against you. Firearm is a legal term, and you should read the written admonishment I provide you to see what devices qualify as a firearm. If you have questions about the laws that make you ineligible to possess a firearm or ammunition, or about how long that lasts, you can talk with Ms. Perazzo. All right, good luck to you, sir. You can go back with the bailiff. Thank you, Ms. Perazzo. Mr. Wilkerson, you've got Larry Fletcher. Looks like that's also a bond hearing.
Absolutely, Your Honor. And Larry Fletcher, Your Honor, we have a number of witnesses here.
All right, give me just a minute then. All three of yours are bond hearings?
Yes.
Okay, give me just a minute then. Huh? That's okay. Mr. Rennick, you've got Tyron let's get Tyron Henderson. The sentencing. Mr. Smith, this is yours on Tyron Henderson. I'm good. Good morning. All right, sir, you are Tyron Henderson. And Mr. Henderson was previously in court. We've got 3 MTRPs and a new case, and he entered pleas of guilty, or a plea of guilty in that new case, and pleas of true to counts 1 through 6 in each of those motion to revoke probation cases. I've received a pre-sentence report updated. Wait, is there a 5th one? Or just 4?
There's 4 cases. 3 MTRPs.
That's right, something was just printed twice. Has everyone had an opportunity to review the pre-sentence report?
Yes, Your Honor. Yes, sir.
Are there any additions or corrections?
Not notification.
So I'm a little, well, probably a little more than a little concerned about your ability to be successful if I put you on another probation, because you were on probation for 2 cases, an evading and an unauthorized use of a vehicle from 2021. Then you pick up a felony theft in 2023, keep you on probation, add a probation on that case. So now you've got another felony while you're on all of these probations. You've already been to ISF. I just need some help here. And Ms. Joseph is here. Ms. Joseph, what's your thoughts?
I believe that Mr. Henderson can satisfactorily complete his probation terms, even with the addition of another term. Mr. Henderson, from the start, and I had frank conversation with him about his current situation as well as the subsequent offense. He understands the seriousness of it, the unnecessariness of this event, and he offered no excuses, which is refreshing. When I notified him of the warrant, he did not hesitate, and he turned himself in. When I spoke with him at the correctional facility, he stated that he would accept whatever the consequences were or would be.
Well, and another thing, Mr. Henderson, which is a bit of a breath of fresh air around here, is you have absolutely no jail reports. And with the group of young people your age out there, that is pretty amazing, because they're acting like fools, aren't they?
He's been in actually for 120 days too, so it's not just a short stint.
So the recommendation is ISF again. which I'm not opposed to. I'm sorry.
A state jail sanction for 180.
Okay, that's not what it says on here.
Well, that was my recommendation.
Is there an issue with misuse of drugs?
No, it's cognitive.
Safety's.
I didn't recommend ISL. I recommended 180 day state jail.
Just 180 days
Yes,
upfront
that's-
time.
He's already been to ISL.
I
so
know.
I don't know why we would repeat that, but that's why I recommend
Same. Okay.
state jail.
Go get a feel for what it's like somewhere other than our
Yes,
jail.
yes. And we discussed that. I told him that's my recommendation and he was willing to accept it.
All right. What do you think, Mr. Henderson? Do you have anything to say?
Judge, can I just say one thing briefly?
Mm-hmm.
He has been in for 120 days. He's had no write-ups. To his credit, every time I've met with him, he's accepted responsibility. He knows this is not a second chance, but a third and fourth chance that the court's giving him.
It's
He's
the
not
last
cynical.
chance.
Yeah.
That's what it
He's
is.
not a cynical young man. He knows that he's made some really foolish mistakes. And this last thing was him doing wheelies on a dirt bike. But I do think that he is someone that can be successful in probation. I think that he realizes too that this is not the path he wants to go down. And with every report and everything he said, he's accepting responsibility
Yeah.
because he's messed up. And I do think he's somebody that, Judge, I really do think I'm not going to see him.
So, Mr. Henderson, I want you to understand, if I go along with this today and you're back in here, I'm going to see all of this and I'm going to wonder what I was thinking today. And that's not going to be good because you will be agreeing today to a certain amount of time in prison. And so we're not going to come in here and negotiate. You mess up again, you're going to be in here getting all the sentences that you're getting. Do you understand? Do you understand?
Yes, ma'am.
Okay. So what is the agreement is just to continue those probations?
Well, actually, the agreement was for ISF cognitive trial.
Okay.
I realized he'd already been.
Yeah. So we've got 2 deferreds on those 21 cases. 5 and 5 years. Okay. In cause number 25 DCCR 0520, I'm going to find that you entered your plea of guilty freely and voluntarily. Find sufficient evidence to find you guilty, and at this time find you guilty of evading arrest or detention with the use of a vehicle. I'm going to sentence you in accordance with your agreement to a term of 10 years in the institutional division of the Texas Department of Corrections, but probate that, place you on probation for 10 years. That's what your agreement is. I am going to order a $250 fine in that case. And I am going to order that you serve 180 days upfront time. And there's not going to be credit for the time you've sat because I want you to see what it feels like to sit somewhere other than Jefferson County Jail. All right. And cause number 21-38934. Find that you entered your pleas of true, freely, and voluntarily. Find those counts true. Find sufficient evidence to revoke your probation, but I'm not going to do so. I'm going to continue you on probation in that case. In cause number 22-39131, also find that you entered your pleas of true, freely, and voluntarily. Find those counts true. Find sufficient evidence to revoke your probation, but I'm not going to do so. I'm going to continue you on probation in that case as well. And then finally, in cause number 23 DCCR 0899, find that you entered those pleas of true, freely, and voluntarily. Find sufficient evidence to revoke your probation, but I'm not going to do so in that case either. I am going to continue that probation. Cause number 21-38934. That's the evading arrest or detention with the use of a vehicle. So that's that first evading. I am going to, I'm continuing your probation, but I am going to extend it by 2 years. All right, so that's now a 7-year probation instead of a 5. Make sure to make that note. And then the other ones, I'm going to leave that other one. Okay. All right. So I'm going to hand you the trial court certifications in each of these cases, Mr. Smith, if you don't mind. This shows these were agreements that I followed, and so you waived your right to appeal. This new case, I want to make sure again that we're very clear that if you violate any condition of probation from this point forward, you are looking at a 10-year sentence in the first evading, 2 years state jail in the first unauthorized use, 2 years state jail in the theft, and 10 years that you just agreed to in this case. Do you understand? So it's very important that you do everything. It sounds like Ms. Joseph believes in you and that you can do what you've showed that you can follow the rules in jail and for some time out of jail, but you've got to follow the rules all the time or you're going to end up in prison and nobody wants that. All right. So take advantage of this situation. When you get out of doing your upfront time, go straight to probation, follow all of those rules, and hopefully we won't see each other here again. All right. Good luck to you. You can go back with the bailiff.
Are we not in state jail? Upfront time is the regular.
State jail upfront time. Yes, ma'am. Sorry. Okay, we have Deshaun Robertson with Mr. Wilkerson. Okay, I'll hold that then. Whoops. Just a minute. Mr. Macon, you didn't have anything else on the docket. Okay. Mr. Lewis, you have Christopher Falk. Christopher Falk. Good morning. Good morning. How are you? Good morning. Are you Christopher Falk? And this is cause number 24, DCCR 1891. I'm going to take judicial notice of the court's file. Mr. Falk was examined for competency to stand trial by Dr. Papon. I don't know if we've done this yet in court. We did already. So I did already make that finding that Mr. Falk is competent based on that report. Is there any other evidence with regard to competency?
No, not from the state. Not from the state judge.
All right. Will he waive the formal reading of the indictment?
He does.
And we're going to count one only, third degree. Okay.
Second count paragraph.
All right. Thank you. All right, Mr. Falk, in cause number 24, DCCR 1891, the state's elected to proceed on count one only. It alleges you committed the third degree felony offense of assault on a public servant, and that is from August 19th of 2024. And how do you plead to that charge? Are you pleading guilty freely and voluntarily? And are you pleading guilty because you actually did what they've charged you with? I have here on the computer some documents that have your signature on them that the state has marked as exhibit number 1. Before you signed these, did you go over them with Mr. Lewis?
Yes, ma'am.
And do you fully understand them?
Yes, ma'am.
And do you understand, if I follow the agreement that you've made with the district attorney, that you'll be waiving or giving up any right to appeal? Also, do you understand, if you're not a U.S. citizen, that a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law? see state tenders number 1.
No objection, Judge.
It's admitted. Mr. Falk, I'm going to find that you entered your plea of guilty freely and voluntarily. Find again that you're mentally competent, you understand the nature and the consequences of that plea. Find sufficient evidence to find you guilty, and at this time find you guilty of assault on a public servant, third-degree felony. Sentence you to, in accordance with your agreement, to a term of 4 years in the institutional division of the Texas Department of Corrections. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. I'm handing you the trial court certification that shows this was an agreement that I followed, and so you've waived your right to appeal. I have also handed you a written admonishment regarding your ineligibility to possess a firearm or ammunition. Because of the judgment entered against you, you're ineligible under Texas law to possess a firearm or ammunition. Possession of a firearm or ammunition could lead to charges against you. Firearm is a legal term, and you should read that written admonishment I provide you to see what devices qualify as a firearm. If you have questions about the laws that make you ineligible to possess a firearm or ammunition, or about how long that lasts, you can talk with Mr. Lewis. All right, good luck to you, sir. You can go back with the bailiff. See, Mr. Lewis, you have Kevin Tran. It says it's locked. Thank you, and bless you too. All right, are you Kevin Tran? And Mr. Tran, in clause number 2137560, 2138780, 25 DCCR 0422, 25 DCCR 0423, 25 DCCR 0424. I'm going to take judicial notice of the files in all of those cases. Looks like the first 2 cases, he's on probation, and then we've got new offenses as well. Mr. Tran was evaluated for competency to stand trial by Dr. Grapon. I received that report dated July 21st of 2025. The finding in that report is that Mr. Tran is currently not competent to stand trial, and that inpatient restoration would be called for. Is there any other evidence with regard to competency?
No, Your Honor.
All right, then based on that report at this time, I am going to find that Mr. Tran is not competent to stand trial, find that inpatient competency restoration is required, and order that he be sent to the appropriate facility for a period of not to exceed 120 days from the date he gets to that facility, and then we'll await a report. Mr. Tran, we're going to try to get you some help so that you can understand everything that's going on, and then we'll get you back in court as soon as we can. You can go back with the bailiff. And then you've got a Michael White.
Yes, ma'am.
Mr. Lewis. He's already been and come, now he's back.
He's back, but he's not, he's still, they don't believe he'll either be restored or be restored.
Okay. So,
You guys had those.
all right, you're Michael White. And this is cause number 24, DCCR 0782. And Mr. White was previously found not competent to stand trial, sent to the Dunn Behavioral Science Center. And we received a report from them dated April 4th of 2025. That report is from Samantha Guzman, and the opinion in that is that he is still not competent to stand trial, with the finding that outpatient competency restoration could potentially be something that would work for Mr. White. The problem with that is that we don't have an outpatient competency restoration program. And so, and that he's not likely to achieve competency. So I don't know exactly where that leaves us. Mr. Smith, what's the?
Judge, I believe his mother lives in Florida. She's willing to take custody of him. And I believe they have a program that is along the lines of this with outpatient competency restoration.
Yeah. Would we do that through a civil, or would it be a dismissal?
That was the question I had on you. We're willing to do whatever it takes to get him there.
And Judge, if I may, I've been talking with his mother. She's been in contact with the probation department there, just trying to get them familiar with what kind of programs they have. They have a program there called the Gateway Program that works with their mental health department. That's basically similar, goes along parallels to what this would be. And the only issue that they've been having to try to get information on Mike, because my understanding, they can't do the interstate compact without it having an out date or anything when they would be getting out to leave to go down there.
But I can't, is this a motion or is this a new case?
It's a motion, because he was sent back from ISF, Judge.
Yep.
Okay.
He was sentenced to ISF as a term and condition of the probation term.
Mm-hmm.
He got to ISF and then started to regress.
Right.
So I can, without pleas of true or not true, really, I think on that motion, I think we can just order that he live in a certain place, which would be with her, that he participate in those programs, and then the probation could transfer to that, correct? I mean, we can't do obviously any kind of pleas on anything.
Right. No,
So it would
agree.
require a dismissal of the motion to revoke.
I don't know, do we actually have a motion filed? I believe we just had this set for hearing because he was returned from ISF.
Gotcha. Okay. So then we just need probation to do the, I don't know if you would necessarily take an administrative hearing or just send in me the order to sign, ordering the Gateway Program through, and if you can get the county and the address of it, where his mom lives, and you get all of that.
Address and that information this morning, so I
You can get all that to probation. Does that sound like something we can do? Okay, well, let's do that then. We'll just not go forward with anything, motions here. Let's just, whatever conditions you need to add with regard to him being able to go there. And then we can kind of figure out when that's going to happen so that they can get transportation. So if you'll work with probation, y'all get all that worked out.
Okay.
Okay?
No problem.
All right. We're going to get it where you can go live with your mom in Florida, okay? But you still have to follow the rules. Oh. I don't know if that's a good thing or a bad thing.
He's thinking you like
He's like, oh no, not my mom. Don't make me go to my mom. Let's see, Miss Holmes, you have Jamel Caddy. She must be in the back. Let's see, Mr. Parker, how about Alfredo Gayton?
We have that, Judge.
Alfredo Gayton? We have so many hearings this morning. Morning. Y'all marked, second degree.
We're gonna proceed on, at least one of the priors to the court's permission. It is not something, there are additional priors that would enhance him that are not required in underlying, if that makes sense. Jurisdictionally, they're not required, but.
Let's see, so it looks like there's two, the first two are, well, we've got a,
So he received 5 years TDC on the 93 case and then 90 days on the 98 case. And then my position is that at least that 2004 or the 2009, whichever the court would like to recite, would enhance him from the third to the second.
so he'll plead on all, let's say, except for that last one, because that would actually enhance it again. All right, so you'll waive, the March 3rd, 2009. We won't go on that, but everything else. Does that make sense to you too, Mr.
Yes, ma'am.
Parker? All right, sir, are you Alfredo Gayton?
Yes, ma'am.
And Mr. Parker, will your client waive the formal reading of the indictment?
He will, Your Honor. I give you.
Mhm.
Okay.
I think so.
Yeah,
I think I already
did.
signed it and
Okay.
handed it over. Give me just a second to get this pulled up. Mr. Gayton, in cause number 25 DCCR 0184, you're charged with the third-degree felony offense of driving while intoxicated, third or more, and that's for March 30th of 2024. The indictment alleges you were previously convicted of driving while intoxicated September 28th of 1993 in Harris County, Texas, and then after that, and then on July 9th of 1998, convicted of driving while intoxicated in San Patricio County, Texas. And then after that, you were convicted on July 28th of 2004, again in Harris County, of driving while intoxicated. And how do you plead to that charge?
Guilty,
And are those prior convictions true?
yes.
Did you enter your plea of guilty and true freely and voluntarily?
Yes, sir.
And because you actually did what they've charged you with? I have here on the computer some documents that have your signature on them that the state has marked as exhibit number 1. Before you signed these, did you go over them with Mr. Parker?
Yes.
Do you fully understand them?
Yes, sir.
And do you understand if I follow the agreement that you've made with the district attorney that you will be waiving or giving up any right to appeal?
Yes, sir.
Now, it looks like the agreement that you've reached is for a cap of 14 years in the institutional division of the Texas Department of Corrections. I want to make sure you understand you have an absolute right to have a jury come in and determine 2 things. You could have that jury decide if you're guilty or not, and then you could leave your punishment up to that jury if they found you guilty. If we go forward this way, you're waiving that right, and you're leaving your punishment up to me. And as long as I don't give you more than 14 years, then you're waiving any right to appeal. Do you understand? Also, do you understand if you're not a U.S. citizen, a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law?
Yes, sir.
State tenders number 1.
No objection.
It's admitted. Is there any evidence that Mr. Gayton is not competent?
No, Your Honor.
All right, sir, I'm going to find that you entered your plea of guilty and true, freely and voluntarily, find that you're mentally competent and you understand the nature and the consequences of that plea, find sufficient evidence to find you guilty. However, I'm going to reset your case for sentencing so that the probation department can do a pre-sentence report. That'll give me more information about you and your case, and then we'll come back later for sentencing. Anything that you think is important for me to know, be sure and get that information to Mr. Parker, and he'll present it to me on your behalf when we come back. All right, you can go back with the bailiff. Thank you.
She didn't have that.
Sean Harley, Mr. Parker. Huh? Oh,
Hey, I just didn't want to sleep.
okay.
So I wouldn't be surprised if he changed his mind. He said he wanted to change his mind, but then he got to change it. He takes it back.
Good morning. Are you Sean Harley?
Yes, Sean.
And Mr. Parker, will your client waive a formal reading of the indictment in each case?
You will, Your Honor.
Mr. Harley, in cause number 24-2148, you're charged with the state jail felony offense of criminal mischief. And that's from August 28th of 2024. And how do you plead to that charge?
Guilty, Your Honor.
Are you pleading guilty freely and voluntarily?
Yes, Your Honor.
And are you pleading guilty because you did what they charged you with?
Yes, Your Honor.
And then in cause number 25 DCCR 0739, you're charged with a third-degree felony offense of harassment of a public servant. That's from August 28th of 2024. And how do you plead to that charge?
Guilty, Your Honor.
Again, are you pleading guilty freely and voluntarily?
Yes, Your Honor.
And because you did what they've charged you with?
Yes, Your Honor.
In each of these cases, I have here on the computer some documents that have your signature on them that the state's marked as exhibit number 1. Before you signed these, did you go over them with Mr. Parker?
Yes, Your Honor.
Do you fully understand them? And do you understand, if I follow the agreements that you've made with the district attorney, that you'll be waiving or giving up any right to appeal?
Yes, Your Honor.
Also, do you understand, if you're not a U.S. citizen, that a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law?
Yes, Your Honor.
State tenders number 1.
Objection.
It's admitted. Is there any evidence that Mr. Harley is not competent?
No, Your Honor.
All right, Mr. Harley, in each of your cases, I'm going to find that you entered your pleas of guilty freely and voluntarily.
Yes, Your Honor.
Find that you're mentally competent and you understand the nature and the consequences of your pleas. And cause number 24, DCCR 2148, find sufficient evidence to find you guilty. And at this time, find you guilty of the state jail felony offense of criminal mischief. Sentence you in accordance with your agreement to a term of 1 year in the state jail prison. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. And then in cause number 25, DCCR 0739, also find sufficient evidence to find you guilty. And at this time, find you guilty of the third-degree felony offense of harassment of a public servant. Sentence you in accordance with that agreement to a term of 3 years in the institutional division of the Texas Department of Corrections. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. These cases will run concurrently, which means together at the same time. I've handed you the trial court certification in each case that shows these were agreements and that I followed, and so you've waived your right to appeal. I have also handed you a written admonishment regarding your ineligibility to possess a firearm or ammunition. Because of the judgments entered against you, you're ineligible under Texas law to possess a firearm or ammunition. Possession of a firearm or ammunition could lead to charges against you. Firearm is a legal term, and you should read that written admonishment I provide you to see what devices qualify as a firearm. If you have questions about the laws that make you ineligible to possess a firearm or ammunition, or about how long that lasts, you can talk with Mr. Parker.
Yes.
All right, good luck to you, sir. You can go back with the bailiff. Kashawn Pugh, Mr. Parker.
That last guy thought they're running CC what cases in jail, in probation. He didn't do probation.
Because what?
Because he thought that his time that he's serving in jail right now would run CC, that it would eat up his case. He only has 2 months of his case after that. I mean, I explained to him for 45 minutes.
Judge, on this, we have a plea in the new case and an offer on the probation of the court accepted based on the reasoning that he has no prior felony history.
Okay. I'll probably do an, I might do it today.
This motion is on the state jail.
Oh, I
New
see.
cases.
Okay, and it's not to continue. Okay. All right, are you Kashawn Pugh? And Mr. Parker, will your client waive the formal reading of the motion and the indictment?
You will, Judge.
Mr. Pugh, in cause number 23, DCCR 1531, you're charged with a third-degree felony offense of evading arrest or detention with the use of a vehicle, and that's from June 18th of 2023. And how do you plead to that charge? Are you pleading guilty freely and voluntarily? And are you pleading guilty because you actually did what they charged you with? In that case, I have here on the computer some documents that have your signature on them that the state has marked as exhibit number 1. Before you signed these, did you go over them with Mr. Parker? And do you fully understand them? Answer out loud, please. Thank you. The court reporter has to take everything down. And do you understand, if I follow the agreement that you've made with the district attorney, that you'll be waiving or giving up any right to appeal? State tenders number 1.
No objection.
It's admitted. And Mr. Pugh, you are a U.S. citizen, correct? Is there any evidence that Mr. Pugh is not competent?
No, Your Honor.
All right, sir, I'm going to find that you entered your plea of guilty freely and voluntarily. Find that you're mentally competent and understand the nature and the consequences of that plea. Find sufficient evidence to find you guilty, and at this time, find you guilty of evading arrest or detention with the use of a vehicle. Sentence you in accordance with your agreement to a term of 3 years in the institutional division of the Texas Department of Corrections. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. And then in cause number 19, 33356. Give me just a second. Yeah.
You just realized we have Adams. I don't know if you need it or not since they came up.
No, not since they came up with something. Thank you, though.
Yes, ma'am.
Actually, let me see that again. No. What I'm looking at right now is your jail incident reports. Don't like being told what to do out there, do you?
That's not the issue. People come to work with problems of their own.
Okay, so it's the correctional officer's faults that you don't follow the rules?
When I walked across the dorm and gave a guy a phone, I did that. I was working out in the bathroom, I did that.
Okay.
Miss Painter, she called me on my name multiple times and I asked her to identify herself. The other things that she wrote in there about me were not true. I had another officer read it to me, so I know what it says.
Okay. There's only one.
Mr. Washington wrote me up, and that was a lie. That's why I got moved to orange, because I actually was in blue at first.
Mm-hmm.
And the lieutenants don't even know why I was in there. I was actually in dorm, placed in dorm under, so to say, Stroder's advisor, but Stroder never wrote me up, so I don't even have a write-up for that.
Okay.
They don't have that in there either.
Okay. I mean, it sounds like you're saying you did most of what they're saying you did wrong anyway.
Most of what they're saying at all. Most of those write-ups, Washington and Painter, and I think another lady, I didn't do the other things that she wrote up. Butte wrote me up for some other things, and I told her that I can't do her job for her. She wanted me to point somebody out, and that was she just wrote me up on it. So.
Okay. So Washington didn't tell you to stop talking, and you responded by saying, quote, "Officer, you telling me we can't talk in the bunk area? You tripping." You didn't say that?
I did not. That man did not tell me nothing that whole day. He didn't. And when I asked him if I had a write-up, he told me no. And then he actually wrote me up 2 days after they moved me from blue to orange. That wasn't even the same
And you
day.
didn't go to the restroom and wash your clothes in the sink and he
No,
told you
ma'am, I
not
did
to do
I
that?
did not do none of that.
You just
I
made
asked
all
the-
that up?
I swear, I asked the lieutenant to check the cameras and see if that's what I did, and she didn't want to do it. So that write-up was just for nothing. When I asked him if he wrote me up because they told me that I had a move card, I said, why am I moving from blue to orange? He said, I don't know. And I was like, well, did you write me up for something? He said, no, I didn't write you up. The lieutenant called and said that you had a move card, that they were placing me in my right because I have a felony case that I'm supposed to be in orange. And when I came in at first, I told them that I was supposed to be in orange, but they put me in blue and told me that they were.
Sounds like you know their job better than them, huh? You're just out there telling them what to do and where you're supposed to be and all that kind of stuff. See, here's the thing. I don't have to accept any agreements in here. And I know word out there, it's got to be getting around that I'm not accepting agreements. I'm putting people back in jail because of these incident reports. Because these people are just trying to go to work and do their job, and they don't need you or anybody else telling them how to do their job, where you're supposed to be. You're supposed to be where they tell you to be. You're supposed to wear what they tell you to wear. That's part of being in jail. You don't get to make your own rules. Stop breaking the law and you can do what you want and wear what you want when you're out. Does that make sense?
It does make sense.
All right, so in cause number 19-33356, I have a motion to revoke your unadjudicated probation. This one shows that you're placed on probation December 7th of 2020 for unauthorized use of a motor vehicle. That was a 2-year probation. Looks like it was extended at least once. Is that correct? Okay.
It looks like this motion was filed in 23, so that needs to be worked on. It's just been at large on it since.
Okay. It alleges that you violated your probation. Count 1 alleges that you committed the new offense of evading arrest, June 18th of 2023. And is that true or not true? True or not true? True. Count 2 alleges that you failed to report as directed to the probation department, April 10th, May 22nd, and June 12th of 2023. And is that true or not true?
True.
Count 3 alleges that you didn't work faithfully at suitable employment and provide verification of that. And is that true or not true?
True.
I'm sorry?
Not true.
Okay. Count 4 alleges that you failed to immediately report to the probation officer a change of address and your arrest. Is that true or not true?
Not true.
Count 5 alleges that you failed to provide verification of performing the community service hours as required. Is that true or not true?
True.
Count 6 alleges that you failed to provide verification of participating in the education program for your GED. And is that true or not true? Count 7 alleges that you failed to provide verification of paying court-ordered child support. Is that true or not true?
Not true.
Count 8 alleges that you're behind in your court-assessed fees as of June 26, 2023, in the amount of $2,361. And is that true or not true?
That's true.
So he was at large since 2023? Is that what this, I would assume from this? Since there's,
That's what I would assume, Judge, just from the file stamps and the fact that his last admin was in 23 as well.
so did you just stop going to probation back in 23?
Yes, ma'am.
That's after he got arrested on the new case, apparently. But that's what it appears, Judge.
No, that was before I got arrested.
Yeah, the new case is from March of 2024. So you had already stopped going for
Yes,
almost a
ma'am.
year.
Because she was planning to violate me for
This
any
is-
reason. I don't know why.
It says June 18th of 23, I thought.
I'm sorry, I'm looking at the wrong thing. Hold on. Looking at the wrong thing.
He was supposed to.
2023, June 18th, yeah. Stopped reporting in April. New offense in June. I don't know if I like it or not. Guess it really doesn't matter a whole lot just because it's gonna, I already gave them the 3 on the other one.
We can rediscuss it, Judge, and raise the time.
I'll do it. All right, so I'm going to find that you entered your pleas of true to counts 1, 2. Well, let me go through this first. I have also in this case, on the motion to revoke case, some documents here on the computer that have your signature on them. Did you also go over these with Mr. Parker? And you fully understand them? Again, you understand if I follow this agreement that you'll be waiving or giving up any right to appeal. State tenders number 1.
No objection.
It's admitted. All right, I'm going to find that you entered your pleas of true to counts 1, 2, 5, 6, and 8 freely and voluntarily. Find those counts true. Find sufficient evidence to find you guilty, and at this time find you guilty of unauthorized use of a motor vehicle. Sentence you in accordance with your agreement to a term of 1 year in the state jail prison. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. I'm handing you the trial court certifications, and each of it shows these were agreements that I followed, and so you've waived your right to appeal. I've also handed you a written admonishment regarding your ineligibility to possess a firearm or ammunition. Because of the judgments entered against you, you're ineligible under Texas law to possess a firearm or ammunition. Possession of a firearm or ammunition could lead to charges against you. Firearm is a legal term, and you should read that written admonishment I provide you to see what devices qualify as a firearm. If you have questions about the laws that make you ineligible to possess a firearm or ammunition, or about how long that lasts, you can talk with Mr. Parker. All right, you can go back with the bailiff. Daniel Turner, Mr. Parker.
These guys try to talk their stuff out of a plea.
This courtroom hearing became a major moment for Mr. Watts as he faced sentencing in 2 serious aggravated robbery cases. The prosecution made it clear that probation was not appropriate, pointing to Watts' behavior while in custody and arguing that if he could not follow the rules in jail, there was little reason to believe he would follow the rules while on probation. The state asked the judge to impose 17 years in each case, emphasizing the seriousness of the offenses and the concerns surrounding his conduct. But the defense painted a different picture. Watts' attorney argued that despite the seriousness of these charges, Watts had no known juvenile record and no known adult criminal history. According to the defense, these 2 cases were the only criminal matters Watts had ever faced, and they asked the judge to consider giving this young defendant a chance at probation instead of sending him away to prison. When Watts was given the opportunity to speak, he directly apologized for his actions. He told the judge that he genuinely regretted what happened and said that if he ever had the chance, he would personally apologize to the woman involved. He also tried to explain some of the disciplinary write-ups he received while being held in maximum security, arguing that some of those incidents were difficult to understand and that he had been placed in an environment where staying out of trouble was not easy. But as the hearing continued, Watts also claimed that he had been influenced by someone older than him, possibly his own